resolution, and especially this consent terms. Yeah, do you think that would have also helped? What are your views on this?
Before I start on lighter vein, I must say that as a lawyer, I should not be aggrieved by this litigation getting prolonged and all. But having said that,
the famous dialogue, Tariq pe Tariq.
But on a serious note, 2-3 significant changes have been made by the government and all. Especially, let's say, on the larger industry, corporate front and all, there has been this formation of this National Company Law Tribunals. Earlier, this Companies Act was envisaged long back in 2002, but it was caught in quagmire before Supreme Court. Somebody challenged the constitutionality of it and all. But subsequently, in 2013, it actually came into force and all. And now, most of the provisions, they are effective and all. So, insofar as corporate disputes are concerned, now we have this expert agency which will deal with all sorts of corporate disputes. And here, people with those domain experts and all, they have been put on the benches and all. Multiple benches have been created all over India and all, which was not there earlier. And plus the layers of appeals, they have been reduced now. Now at least we have this National Company Law Tribunal. From there, if the matter is to be escalated higher, it goes to this appellate tribunal and thereafter directly to Supreme Court. So there's only one intervening gear in between. And there again, what the Act has contemplated is, insofar as Supreme Court is concerned, the appeals will go only on very narrow point, that is on points of law, not on facts and all. On facts, the findings will be final as such. Whereas in earlier regime, we had this company law board, and we put single judge bench and division bench, thereafter Supreme Court. It used to take ages and all. Now at least we have this domain experts who will deal with this matter. So that will, I mean, the hope is that these litigation matters, insofar as corporates are concerned, they will get resolved sooner. And second intervention was with regard to this insolvency and this bankruptcy code and all. There again, a lot of NPAs were gathering dust and all. Now, so far as this code has been formulated, now it is more of a credit-driven process. Earlier, which used to be data-driven process and all. So that's also one of the major changes and all. And here again, the adjudicating authority again is National Company Law Tribunal. So this body, to my mind, will kind of expedite this entire litigations insofar as corporates are concerned on larger scale. Second significant intervention which has been made is with regard to this arbitration process and all. Long time back in 1940s, we had that Arbitration Act, which was again changed, and a new act had come into force in 1996. But again, that was not in a position to meet with the competing needs of the time and all. So now, in 2015, amendments have been made to this Arbitration Act also. Because most of the potential investors from abroad and all, first thing that they want to assess is what is the governance risk they have. In case, let's say, if the matter lands up in some kind of dispute, how sooner it will be resolved and all. But given the prior to amendments, this act was not meeting with their requirements, or maybe these arbitrations were getting dragged a lot. But now significant amendments have been made, wherein this entire process has been fast-tracked. Just to mention a few of the provisions, like one process is that you have to complete this arbitration within a time frame of 1 year. Now that is a very significant departure from the earlier cases and all, because otherwise matters used to drag a lot. And here again, disincentives have been imposed on the arbitrators, let's say in case if they stretch the matter beyond 1 year, and only one permissible extension is there for 6 months. So at the highest, it will be for 1.5 years. And let's say in case within that time also, if the arbitration is not wrapped up, then it automatically gets terminated. So that acts as a very good disincentive for the arbitrators as such. Secondly, arbitrators have been again given pass that in case if a lot of adjournments are being sought, to impose heavy costs on the parties as such. And plus here again, we have this another fast-track procedure, wherein let's say two parties are there, they don't want to get into this oral arguments as such. Everything will move on the basis of written pleadings and all. And then they can say within 6 months, this entire matter has to be resolved. That's another good departure and all. And plus now we are also seeing significant mindset change in courts also. Because earlier everything which used to get appealed to courts and all that, they will treat it like just an appeal as such, and they will entertain it. But now this lot of commercial agreements, whenever they are being entered into by parties and wherever these arbitration clauses are there, now these days the courts are quite reluctant to entertain any challenge to award and all, unless until it's very grave. So that was another intervention which was made by the government. Now insofar as specifically capital markets are concerned, we have this settlement regulations, as you just asked about this consent terms and all. These settlement regulations actually earlier they were in the form of circulars which were issued by SEBI way back in 2007. A lot of disputes were raised with regard to its legal tenability as such. Now from circular, now they have elevated it to the form of regulations which came in 2014. Now in 2014 settlement regulations and all, they are quite comprehensive, and then they have elaborate procedures and elaborate formulas how the settlement amounts will be worked out with regard to potential, let's say, notices those who approach SEBI as such. Earlier it was not there. Now at least specific formulas are there, so that reduces the arbitrariness part of it. And the whole objective and idea behind the settlement regulations was so that at least small technical kind of disputes should not get escalated to level of appeals before the Securities Appellate Tribunal and all. And it has really worked very fine and all, because most of the times, let's say, some inspection related disputes are there with regard to intermediaries, or some disclosure related disputes are there, or maybe there are some minor violations here and there. So at least those kind of things, they can be tackled at the level of the settlement regulations. And it's good for both the sides. Even SEBI is also not unnecessarily burdened with unnecessary cases wherein they also have to deploy their litigation machinery before SAT and people take it otherwise. And similarly for this notices also and potential intermediaries. Because then ultimately that takes away the focus from their actual work to get busy with this litigation part and all. And that has really worked very well.
Very encouraging to hear that.
Yeah.
Mr. Raman, I'll just come back to you. You know, Mr. Haribhakti mentioned about a number of people who are salary earners, and if you look at India as a whole, I think direct equity exposure is probably not more than 2% of the population. Do you think, since you have played various roles, that is this because of something to do with ease of entering capital markets or something beyond that? And if it is, what can we do, regulator as well as us, in terms of increasing this base? Because this seems to have been stagnating at this level for the last 2-3 years. You don't see any significant change.
No, that is a very sound observation, and it does, puzzle all of us here that how come that base is still the same? I mean, it's not that our population has grown so fast that the numbers have gone up, but my guess is that the ease of putting your money into the non-formal, segments of savings. So be it gold, be it property, be it, whatever other such easy form. I would suspect that it makes a lot of sense not to be seen. So, why should I put my money somewhere where I can be seen easily? Now, the world has changed, recently from November 8th onwards. And I think the realization is now that it's, you're safer probably, putting your money into instruments and letting the whole world or the, tax department know where your money is. And I just borrow from a point which Mr. Swami said. I mean, I'm aware that the income tax department today is bordering at a point where you and I should feel worried that do they know too much? So, I'm sure in India that debate will come about, and it's time that debate should come about. Because, how much can an income tax department know that what all I do and, where I go and visit and, what my hobbies are or whatever, because it's all available. I mean, once you're on a, non-cash transaction basis, you leave a footprint on the digital space. So, but having said that, I don't know, I mean, I don't have the statistics, but I would say that pushing mutual funds into the country is extremely sensible. The big question I've always asked myself is, why is it that we're not selling debt?
Right.
Why is it that the so-called, debt mutual fund or the liquid fund is not being sold to, maybe not people like you and me, but, the youngsters who are, into their first job, or, the lower middle class segment, which is really, I think, where the money is and the safety has to come in. Why is it that we're only selling equity? There is a certain, understanding of the mindset of the person that you're selling a product to. I still think a lot of India goes back to post office saving instruments. It's very, very large even today. In fact, there's something called a postal life insurance, which is huge. It beats, I think, even LIC in the sheer amount of the assured sum that they hold. So we probably need to rework instruments which make it much easier, and therefore, to me, intuitively, the mutual fund route seems a very sensible way of taking it forward, but we should probably understand why is it that the debt mutual fund is not being sold so easily. What are the problems behind it? Is it that there's not enough paper? That is probably, it could be one reason. And if there's not enough paper, then there are, structural issues in a debt market. That is, I think, an incredibly important part. And, one of the things which the Insolvency and Bankruptcy Code wishes to do, and it's written there in its deliberations in the working, in the BLRC, which put it together, is to widen and deepen the debt market. And therefore, be able to allow creditors to go on to their debtors far more quickly. So, in fact, just for your information, there are 7 cases which have gone to the NCLT by creditors against their debtors. And we were told that there were 2 other cases filed by the creditors, and the debtors immediately upon getting notice settled with the creditors. Because somewhere the law is a more meaningful law, it's a more hard-hitting law, it's got strict timelines. So maybe we are at that cusp where we'll end up working on debt more, because the legal infrastructure and the implementation of that legal infrastructure, which I think frankly is the most difficult part, will probably end up helping debt instruments to become stronger. People will have more faith in the kind of debt instruments they're dealing with, because resolution and recovery is visible. Today it's lost. Vinay is completely right. I mean, everything takes 15 years. I mean, not in the capital markets.
Mr. Haribhakti, 2 or 3 things that, if you had a wish list in the role that you play, that you would want in capital markets to change.
So the first thing on my wish list is that we need to give people the practice of actually owning shares.
Okay.
And there's an easy way to do it. I had made the recommendation that the way to recapitalize banks is perhaps to not just put the money into the Jan Dhan bank accounts for nothing, but directly transfer them to bank equity.
Okay.
And that's an idea that I have been trying to push for a long time, like 6-8 months. And obviously with all these, with non-synchronous elections, we don't get a chance to get things going. But it's an idea which Thatcher used 25 years ago, something like that.
Right.
That's exactly what happened. What she did is she made everybody a mini capitalist by making sure that the British equity was available to the entire British population, by simply discounting the value of the British PSUs.
Right.
And I don't see any reason why we should not give people that jump start to make sure that they become used to having a DP account just as they are used to having a bank account. I think it's just that little mental shift that we need people to make. The other is the overwhelming apparent complexity. Actually, equity and there's debt. There's no rocket science nahi hai. But all of us together have conspired, I would say, to make it convertible, optionally convertible, put and call option, all kinds of rubbish which really makes no sense. And so the person is confused and he freezes up and says, I don't want to get anywhere near this. But if it was simply equity and debt, and they knew exactly what happens, we would have a much more vibrant shareholder base.
So maybe we should, take lessons from some of the apps which are so simple to use and apply it in the capital markets also. Just as you
It's
said.
crazy, the amount of unnecessary complexity we've woven around this whole thing.
What about you? What would you think, changes in legislation or taxation which would make it even more easier for people to be active in the capital markets?
No, I think if you ask me, currently the tax regime, to my mind, is fairly stable. I think we have long term at 0 and short term at 15. Yes, there is some amount of STT, which is a cost and not a deductible cost. Yes, I think subject to that, I think we have a fairly good regime and it's been stable for some time. So my expectation is, I don't expect that regime to change, or rather I would expect that regime to remain stable for a long period to come, because that's what probably investors understand today and that's what they will want. Maybe I can touch upon a couple of points which a foreign investor will want to see in some changes coming up in the immediate future. So you may be aware of the famous Vodafone rule, which was brought in the domestic tax law and which gave India a lot of bad press. Essentially, what Hutchison did was sold the Indian company, but not sell the Indian company straight away, but it had a tiered structure, and it sold, say, the shares of a Cayman company. One share of a Cayman company was sold to Vodafone, and they took $10 billion. They said nothing is payable in India, and they just walked off. But then Vodafone came in, Indian government went after that, saying that there was a tax deductible on that share transfer, and there was a $2 billion of tax which was payable. And Vodafone litigated right up to the Supreme Court. It got in favor, and then the Indian Income Tax Act was amended. The act was amended in a manner which said that if the share or interest which is transferred overseas, if that derives its value from an asset which is located in India, then that foreign asset transfer is also subject to tax. Now, when they brought in this amendment, it was primarily targeted for strategic type of transfer. But since the law was very generic in nature, it even applied to many of the foreign investors, right? Portfolio type investors, the kind of Indian mutual funds, I mean, similar foreign mutual funds which are investing in India, I mean, it applied to even them. And there was a lot of concern which the foreign investors had expressed. So in this budget, they did bring in a change. They brought in a change saying that if you're a foreign portfolio investor, category 1 or a category 2, then this particular law will not apply. But as the current law is, as far as the SEBI regulation is concerned, there are 3 set of categories, right? Category 1, category 2, and category 3. But there is no real reason why, from a tax standpoint, you have to make a differentiation between category 1 and category 2 and treat a category 3 differently.